now.
Okay, we are back on the record. Okay, next we'll move to the respondent's motion in limine. Mr. Knight, this is your motion. I'll have you present your argument, and I'll hear the response, and you'll have an opportunity to reply. You may proceed.
My motion for in limine is to limit the documentations that had already been litigated on before and up to the trial of 8/21/17 on the final parenting plan. Ms. Voss has amassed a lot of documentation that has already been litigated upon, and I feel it is prejudice towards me to be litigated on multiple times on the same exact issues. Our trial ended on, or the final parenting plan was signed on 8/21/17. And after 8.5 days trial and 27 professional people, including 3 psychiatrists, were involved in this. So I don't see any reason why we should have to relitigate it without the professionals here to back up all the information that was presented. This is just more, it's prejudice towards me to have to do it without my attorney. I have had attorneys through a couple of times, and now Ms. Voss has me in here without an attorney. I'm broke, I have no money, I cannot buy an attorney. So I'm trying to defend myself the best way I can. I have a friend of mine who has been helping me with some paperwork. That's the only reason why I have got it as far as I have. So as far as the limine, I do not feel that Ms. Voss should have any documentations prior to 8/21/17.
Ms. Petrie Ramirez, your response.
Thank you, Your Honor. In regards to the respondent's motion in limine, he's making a res judicata argument. And when we're talking about res judicata, concurrence of identity in full respects, we're talking about subject matter, cause of action, persons or parties, and quality of the persons for or against whom the claim is made. And this was established by Norfolk Construction. Additionally, it has been found by the courts that to determine whether a cause of action are identical for the res judicata purposes, the courts should consider whether the second action would destroy or impair rights of interest established in the first action of interest, established in the first judgment, whether the evidence presented in the 2 actions is substantially the same, whether the 2 suits involve infringement of the same rights, and whether the 2 suits arise out of the same nucleus of facts. Here we are presenting these documentations where we have claims against the respondent of mishandling the minor child Chloe, who's now goes by the name, as I've been told, by Rice. And it's important to have these documents present in order to make sure the court understands the history of the case. Additionally to that, to understand the medical history of the very complex diagnosis that the children have, and additional to that, with the mental health and stability of the petitioner as well as the respondent, which are claims that are present in this case. We don't have any actual reports that are not prior to the 2017 trial that, because of these allegations that have been in this modification, are pertinent to have the court look at. Additional with the complex medical issues of the children, it seems like from the documents that I've read, Mr. Knight's position has changed, and in these previous documents it provides with the history of this medical issues and in regards to the children's allergies and all these prior diagnoses that should be taken into consideration. Thank you.
Your reply.
It's still just a relitigation of the trial from 2017. Ms. Voss has been not pleased with the decision from 2017. She is engaged in abusive use of conflict throughout the last few years by filing adequate cause here in Mason County. in 2018, which was dismissed due to lack of evidence, and then Ms. Voss has now started a new adequate cause with some more false allegations. She's simply trying to use the same stuff that she has beat me over the head with the last 12 years to try to continue to beat me in the head with it, sir. And I do not feel that, I feel it would be prejudice towards me if the courts allowed it, and did not go from at least at the end of the trial till today, and make that acceptable. Anything prior to that should not be acceptable. It has been litigated upon. I rest.
The genesis of this action in this court is a petition for modification, and that modification does relate back to the Thurston County order that was entered on August 21st, 2017. What the court will be considering as relevant in this case are what have been the changes in circumstances since the order of August 21st, 2017. The issues that were argued prior to that time are not relevant to this case, and to the degree that evidence is being provided for that purpose, the court will find it's not relevant. Mr. Knight, you will be responsible for making those objections. In some respects, I'm granting your motion, but in some respects, I'm not. However, the court also recognizes that this case cannot proceed in a vacuum as well. And so I understand that foundationally, there may be some evidence that needs to be presented to the court for the court to understand what changes in circumstances have occurred. Okay, that is what the court would be looking to. Just purely foundational, though, as basically a starting point, because what's being alleged is that there's been a change since August of 2017. And so the court's going to determine whether indeed there has been a change, and to the degree that there has been a change, what's in the best interest of the children with regard to any modifications that the court's going to grant. And so it is a correct understanding that the court's not going to hear a relitigation of what was before the court was before. However, I think I've made my points clear. Foundationally, it would be appropriate to provide okay. And so, Ms. Petrie Ramirez, we need to figure out something to do here with your microphone. I'm understanding that I think it could be because of the binders. That's a really sensitive microphone, so it picks up really well. And so I know that, and you can utilize furniture behind you, whatever you want to do in order to make sure that you have a clear shot at that microphone, but I just got notified that you're not being picked up very well. Okay. The court is also mindful that there is included in this trial a relocation, and again, we're going to deal with relevance. Okay, is there any evidence that is being offered that's relevant to the relocation that may also have existed prior? I don't know. Sure, it is. It doesn't make. It may not. It may. I don't know. But relocation has very specific criteria that the court looks at in determining whether relocation will be granted or not, and it covers a host of issues that the court has to consider. I think there's like 13 of them. Don't quote me on that. I'm just using my memory. And so again, what the court's going to be looking to is relevance, and the motion limiting has been brought on this very issue, and that's how I'm looking at it. And so the court's going to grant to that degree, but the parties need to be mindful that relevance is one of those in the moment type of arguments that is made. Okay. Are there any other preliminary matters that either party wishes to address before we proceed to opening statements? Ms. Petrie Ramirez? Anything further?
Not at this moment, Your Honor.
Okay. And Mr. Knight, anything further?
No, sir.
Okay, so at this point, we'll move on then to opening statements. The parties can choose to make an opening statement or waive opening statement. Mr. Knight, you have the opportunity to choose to make an opening statement or defer, which means that you would make it at the beginning of your case in chief, at your choice. And so, Ms. Petrie Ramirez, do you wish to make an opening statement?
No, Your Honor, I wish to make a closing argument.
Closing argument, okay? We'll have that at the end. And, Mr. Knight, do you wish to, make an opening statement at this time, or do you wish to
Yes,
defer
I
or
do.
wait?
I would like to make an opening statement, sir.
You may proceed.
To me, this case has started in 2009. I don't care how many different numbers are on these court papers, it's still the same case. It's still the same arguments. I am going to prove with the evidence that Ms. Voss has a mental disorder that makes her want to continuously take me and her previous children's father to court. She has something like 26 years of experience in custody battles. I am weary of this battle with her custody issue. All I've been trying to do is do what the courts had gave me the authority to do, which was take care of my children's medical needs. I was awarded in 2017 full custody. I then gave Ms. Voss 50% residential time because I believe my children need to have both parents in their life, healthy parents preferably, but they still need to have parents, good healthy parents in their life. I have tried numerous times through the years to appease Ms. Voss's needs and wants, but no matter what I do, she continuously wants to take me to court and belittle me and dehumanize me, and it is not beneficial for my children. I have actually seen my daughter's psyche over her entire lifetime go from a happy little child to now we have a psychiatrist showing up at our house 4 times a month because of all of this turmoil in her life. And I'm done with the turmoil causing my children mental illnesses. They're going to have therapy for many years to come due to this. I simply would like the courts to make note that Ms. Voss has made lots of allegations, and behind her allegations are a lot of lies. There are a lot of half-truths, and they were just her opinions. I have tried to be the best father I can be for my children. I've always wanted to have children. I'd never had children until I met Ms. Voss, and I was not going to not take care of my children. And Ms. Voss has been trying to take my children from me my entire life. I believe my children need a good father. They don't need a good lawyer. I never wanted to be an attorney. I never wanted to have to do this. I'm a maintenance man. I fix things. I take care of my children to the best of my ability. I am not trying to harm my children in any fashion. I want them to prosper. I want them to be the best children they can. And I think the only way that that can happen is for this court to make a positive decision at the end of this so that this fight will stop. That's all I ask for, is for it to stop and for me and my children to be left alone and have peace and enjoy our lives without turmoil in it. Thank you, sir.
Okay, Ms. Petrie Ramirez, you may call your first witness.
Your Honor, our first witness would be Draven Alexander, although I miscalculated and had her for 1:30 since I've been thinking that the preliminary issues would take most of the morning.
Okay.
Yeah.
Are you expecting her to appear via the Zoom channel?
Yes, Your Honor.
Okay. Okay, and so I understand how these scheduling things work. So what we will do is we'll go into recess. I have a 1:15 resentencing on a criminal matter, but the issues are fairly finite, and I would expect that that will take no more than a half hour. in all likelihood, it could be done in 15 minutes. And so it's at 1:15, I'll be doing it right here from this computer. And so if everybody was present at 1:30 to start up again, then we will do that. It may be a little bit delayed, but if everybody's here ready to go, at least when the court's ready, you will be as well. So I'm going to step down. We'll start up again at 1:30.